A federal trial court judge just dismissed a criminal case around Section 922 sub O. What the heck am I talking about? I'm talking about machine guns. Are they back on the menu though? What does this mean? How did we get here? What happens next? That's what we're going to be talking about. So guys, let's get into it. The Second Amendment extends prima facie, in other words, on its surface, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Those are not the words of me, Tom Grieve. Those are the words of Justice Scalia in the majority decision of DC versus Heller. That's the 2008 landmark decision that really got the ball rolling to where we are today on protecting our Second Amendment. So what that means is that on its surface, kind of the needle starts at all weapons that are bearable arms, even those that were not in existence at the founding, start off as being protected by the Second Amendment. However, buried and layered into that statement is the implicit recognition of the fact that not every instrument that is bearable will be protected by the Second Amendment. That is not me that is saying that that's the way that ought to be. I'm just saying the Justice Scalia could have said, every arm that's bearable is protected, we're done. But he didn't. He said prima facie, in other words, on its face, okay? It's the fancy Latin way of saying that. And anytime you hear someone say prima facie, what they're saying is, look, the needle starts on it's protected if it's a bearable arm. But layered into that, of course, is the fact that it may not be protected. And if so, what tests and reasons do we have to do to get there? And that's, of course, part of what we're running in this video here today. So brief definition of arms. Well, we're trying to remember this because, of course, he didn't say firearms. He talked about bearable arms. Heller defined the word arms covered by the Second Amendment to include anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. Gotta love that 18th century wrath and ruin talk, right? So anything that a man wears for his defense or takes into his hands or uses in wrath to cast at or strike another. So that would obviously include firearms. It has been ruled many times, no use debating that fact. So what are we talking about in this case, transitioning to U.S. versus Morgan? Well, Mr. Morgan was in possession allegedly of two machine guns. One was an Anderson Arms AM-15. The other one was a Glock-switched Glock. He was caught in possession of them and was subsequently charged, bringing us to this Kansas court. In court, Mr. Morgan filed a constitutional challenge to this statute, Section 922 sub O, saying this is unconstitutional because machine guns are protected by the Second Amendment. Therefore, this is illegal and you must dismiss the charges against my client. The federal government predictably disagreed with that fact and said, no, this is perfectly good to go. They made a number of arguments, and in a written decision linked in the description box below, the judge basically said, yeah, you know what? Machine guns are bearable arms and the government's arguments fail. Let's walk through these quickly. So the government makes a number of different arguments. I want to focus on two of them. The way that you have to understand how the Brune analysis, Brune, B-R-U-E-N, for those of you listening to this while riding on your lawnmowers or car, B-R-U-E-N. The Brune analysis comes from the United States Supreme Court case in June of 2022, which set out the legal standard and framework that were to analyze firearm laws and regulations to determine whether or not they are constitutional or unconstitutional. If they're constitutional, they can stand. If they're unconstitutional, they ought to fall, okay? That's the Brune analysis, sometimes known now as the history and tradition analysis. We start with the fact that machine guns are bearable arms, and that's going to be critical because once we determine that machine guns, including this court that determined machine guns are bearable arms under the Second Amendment, what that now means is that according to Scalia's language in the 2008 DC versus Heller case, any arms that are bearable gets prima facie protection from the Second Amendment. So how can the government then show that, you know what, this doesn't fit? Well, a couple different ways, and the government really goes down one of them much harder. That's the history and tradition analysis. So to this point, the government is, and I'm going to focus on two of the arguments that they bring up here. The government cites to Blackstone, and then they also cite to a North Carolina Supreme Court case coming out of the 1820s. Let's start with Blackstone. And for those of you who do not know, do not tune out. Blackstone is incredibly important. One of the most well-read English authors on the English law by the founding fathers and that generation of readers. Blackstone wrote his commentaries on the laws of England across the 1760s, and he basically summarized a lot of the jurisprudence of what courts are doing, what are the precedents, as well as what are the statutes that are out there, to encapsulate it all in, it was a number of volumes, but in a way that was cogent and all in one spot, and was also readable for the layman. Keep in mind, you also didn't have law schools back then to kind of muck everything up either, right? So that also helped. So citing to Blackstone as being a preeminent authority is going to be incredibly important. You're going to see both the anti-gun and the pro-gun folks wrestle over what did Blackstone say, because Blackstone's going to be not only at the headwaters, but in a very real sense, the headwaters of American jurisprudence, history, and tradition. So citing to Blackstone is kind of a big deal here. Guys, really quickly, common use test, DC versus Heller, super important. If it's in common use, good chance that it should be lawful. Good chance it will fail some sort of dangerous and unusual weapon analysis or something like that to throw it out. So my question for you is, do you want to see a video where I go through and math out how many machine guns we would probably have today if it was not for the 1986 Hughes Amendment? I'm up for it. I'm not saying it's going to be perfect. I'm a lawyer. No one says lawyers do great math, but I've got an idea about how we can try to capture this. Let me know in the comment field below. Hit that like button. Now back to the video. So within the English common law tradition, you're talking about laws that deal with a weapon that is dangerous and unusual as being no-go under certain circumstances, as well as going back all the way to the 14th century, back to the 1300s. We're talking about something called the Statute of Northampton, which is something that you see a lot of antis cite to. And they implicitly did here as well by citing to this particular part of Blackstone that goes back to Northampton. This is all important because, again, history and tradition, if something falls outside the history and tradition of the United States jurisprudence, then it will probably fail as being unconstitutional. If it falls within America's history and tradition of jurisprudence surrounding weapons regulation in the Second Amendment, then it will likely be found to be legal as a law or regulation. I'm not asking you to like it. I'm just simply saying that's the rules that the Supreme Court has set up. In an effort to keep this video short, which believe me, I'm striving for today among all days, I was not planning on carving time to make this video, but it was too fun and exciting not to. So here I am. The judge basically swatted this citation down. And he did it because he said, look, the issue with the citation to Blackstone here is that the problem isn't with the weapons unto themselves. The problem is what you're doing with the weapons. So it's not just one, it's the combination of action plus the inanimate object that makes it so that you have something that can be illegal. So as an example, the judge writing the decision, again linked in the description box below, said, citing to a 1716, so well before Blackstone, treatise, looked at the fact that it's not wearing the weapons, wearing of arms is within the meaning of the Statute of Northampton, unless it is accompanied with such circumstances as are apt to terrify the people. That's a direct quote. So it goes back to the fact that, look, the weapons unto themselves, they're not the problem. The problem is, what are you doing with the weapons? The court also winds up looking to a particular trial that took part in a couple decades before 1716, in the latter portion of the 17th century, where someone basically wore some handguns into church and around town and was subsequently charged with it. Probably wasn't on the right side of the political divide with the king back at the time. Keep in mind, we had the Glorious Revolution in England back in the 1680s. We had another revolution in the 1640s. This is a very tumultuous and unstable time, okay? And at the end of the day, he wound up being acquitted because in no small part, he wasn't doing anything wrong with the weapons, simply going about town. The judge in this case also not only cited to those two factors, this trial of this knight basically in the latter portion of the 1600s, and also this treatise from 1716, but the court also goes on to basically cite to Brune, who agreed that one's conduct will come within the Statute of Northampton, i.e. would terrify the king's subject only where the crime shall appear to be malo animo. That's Latin for basically with evil intent or malice. That's Brune, page 44. So again, we see this coupling of you've got this item and then how are you using it? And basically the same thing's true for the other citation that the government uses as well, citing to this 1824 North Carolina Supreme Court case that recognized an offense to arm oneself with dangerous and unusual weapons in such a manner as will naturally cause a terror to the people. Same deal going on. This all falls under what we commonly know as going armed or to affray, which comes from the French verb to terrify. So it's not just the weapons. It's got to be coupled up. Why am I talking about this? What is the issue here? The statute that Mr. Morgan's being prosecuted under criminalizes mere possession of a machine gun. Not you have to be using the machine gun in a reckless, disorderly, dangerous, or some sort of way that constitutes the criminal offense. It's mere possession is good enough. Now, keep in mind that machine guns, of course, have become highly regulated since 1934. They've been around for over 100 years now, but it was not until the National Firearms Act in 1934 that we started to see a regulation. That regulation came not in the form of a ban, but in the form of a tax. I'm not asking you to like that. I don't like that, but just the same, you'll see where I'm going with this. Then in 1986, we had the Hughes Amendment to the Firearm Owners Protection Act that was signed into law. The Hughes Amendment made it so that there could be no new machine guns that could be lawfully possessed, transferred, and so forth by civilians, by you and I. So government entities, DOD, police departments, things like that, they could still purchase, possess new machine guns made post-May of 86. But us normies, you and I, we can only have properly registered machine guns that were already on the books as of the magic date in May of 1986. Now, that does not, again, equate to a ban. What it equates to is high regulation. Again, I'm not saying you should like this. I'm just saying that at the end of the day, there has been no machine gun ban. And the closest thing that comes to it at the federal level is the Hughes Amendment. Different states have banned possession of machine guns. That's a separate issue. And by the way, if you want to see a video where I try to figure out how many machine guns would we have but for the Hughes Amendment, let me know by hitting that like button and commenting down below, because I have a couple ideas about how I could try to come up with a number of how many machine guns would be in civilian hands. The regular number these days usually cited to low end 160,000, high end mid 170s. I usually use 175-ish because we've got pretty good numbers to use to kind of date off that. And I did a whole video about what's happening in machine guns, why we're losing them, and all that kind of stuff. If you just search that up, I'll try to get Derek to link it down in the description box below. If you want to see why are we losing hundreds and hundreds and hundreds of machine guns every single year? At the end of the day, between these two facts, not to mention, of course, we get these background issues like the U.S. Supreme Court in 2016 ruling that 200,000 stun guns and electronic devices are going to be completely fine in the Ketamine decision. So there's a lot of background issues you could be going into. The court in Kansas says, good to go. It's a bearable arm, and government cannot meet its burden to show how it falls, how the regulation that criminalizes it, i.e. effectively the Hughes Amendment, falls within the nation's history and tradition. What this does not do is it does not strike down the National Firearms Act. This does not strike down the Firearm Owners Protection Act, of which the Hughes Amendment is a part. This does not mean go ahead and start drilling more holes. It doesn't mean any of those things. Cannot be clear enough. Kansas fits within the 10th Circuit, so there's a good chance that the feds may want to appeal this, given how long things take to wind through the courts. And I don't know offhand how many vacancies may or may not be sitting in the 10th Circuit Court of Appeals. But if President Trump is reelected, it's possible that the feds don't want to risk this because they don't want to see. And the 10th Circuit kind of falls in the middle. They're not the 5th or the 8th or something like that as being pro-gun, but nor are they the 2nd or super anti-gun. They're middle ground as far as things go. But if that could swing heavily to become pro-gun, then you never know what could happen, I suppose. So I think the feds, if I'm a federal prosecutor, I might be watching to see what happens with the election, with also an eye towards how many vacancies might be on the court when this case would be hitting there. Long term, U.S. Supreme Court. I think that this should be struck down. I think the Hughes Amendment has challenges and weaknesses to it, but I don't think it will be. I'm not cheerleading for that. I just don't think it will be. I'm happy to do a video kind of walking through how I think that would play out. But at the end of the day, I don't think we have 5 yeses to striking it down on the United States Supreme Court. And that's what we're going to need. That is the brass tacks on this. So don't hate me for that. Do not confuse that for being what I want to happen. Do not confuse that for my belief of what I would do or how I would cast my vote. It's none of those things. It's simply a prediction about what I think would happen should it get there. Don't forget to hit that like button. Let me know in the comment field below if you want to see that video where I try to math out how many machine guns we would probably have today, which is important under our common use test from Heller. So that's important. And I started doing the napkin math on that. So let me know. That's very real. Our quote of the day comes from Greek thinker Heraclitus, or Heraclitus. I've seen it pronounced both ways. Quote, "You don't develop courage by being happy in your relationships every day. You develop it by surviving difficult times and challenging adversity." Sometimes we have to challenge more adversity by filing lawsuits. That just is what it is. Support your GOA, FPC, SAF, NAGR, and all those great groups that are helping you out, and I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.